Hello and welcome to the 57th Annual Robert J. Beaudry Moot Court Competition. My name is Shauna Pruitt, Director of this year's competition, and I, along with the Barristers Council Appellate Division, thank you all for attending. 227 1L and 1E students registered for this year's competition. Of those who registered, a record 144 students submitted briefs and participated in oral arguments. They addressed the question of whether a public school district policy that requires teachers to lead willing students in reciting the Pledge of Allegiance, which includes the word "under God," violates the Establishment Clause of the First Amendment, as applicable through the 14th Amendment. Of those 144, the top 4 participants sit before you tonight. Arguing on behalf of the petitioner, ABC School District, are Laura Brookover and Jeffrey T. Hantson. Ryan Creighton and Ari Meltzer represent the respondent, James A. Parker. Serving as our Chief Justice this evening is the Honorable Arthur Gajarsa. Judge Gajarsa was appointed by President William J. Clinton to the U.S. Court of Appeals for the Federal Circuit in 1997. Prior to his appointment, Judge Gajarsa was a partner in the Washington, D.C. law firm of Joseph, Gajarsa, McDermott, and Reiner from 1987 to 1997. Since 2003, Judge Gajarsa has been an adjunct professor at the Georgetown University Law Center. From 1980 to 1987, he was a partner in the law firm of Winder, Morass, and White. From 1978 to 1980, he was a partner in the law firm of Gajarsa, Liss, and Conroy. And from 1971 to 1972, he was an associate with Duncan and Brown. Judge Gajarsa served as special counsel and assistant to the Commissioner of Indian Affairs, Bureau of Indian Affairs, Department of Interior from 1969 to 1971. He was an attorney with the Office of General Counsel, Aetna Life and Casualty Company from 1968 to 1969. Judge Gajarsa served as law clerk to the Honorable Joseph McGarrahy, United States District Court for the District of Columbia from 1967 to 1968. Judge Gajarsa received his MA from Catholic University of America and a JD from Georgetown University Law Center in 1967. Serving as a justice this evening is the Honorable Margaret McKeown. Judge McKeown was appointed to the United States Court of Appeals for the Ninth Circuit by President Clinton and confirmed by the U.S. Senate in 1998. Previously, she was a partner in the Seattle and Washington, D.C. offices of the law firm Perkins Co. She was a White House Fellow from 1980 until 1981, serving as Special Assistant to the Secretary of the Interior under the Carter administration. Named one of the 50 most influential women lawyers in the United States by the National Law Journal, McKeown earned her law degree from Georgetown University Law Center. She was awarded an honorary doctorate from the Georgetown University in 2005. McKeown has served on the Judicial Conference of the United States Code of Conduct Committee and the American Law Institute, and is a fellow of the American Bar Foundation, among many other affiliations. She is also an adjunct professor at the University of San Diego Law School. McKeown serves on the boards of Volunteers of America and the Girl Scouts, which gave her its Cool Women Award. We are also pleased to have the United States Solicitor General Paul Clement serve as a justice this evening. Mr. Clement is the 43rd Solicitor General of the United States. He was nominated by President George W. Bush on March 14, 2005, confirmed by the United States Senate on June 8, 2005, and took the oath of office on June 13, 2005. Mr. Clement received his bachelor's degree summa cum laude from the Georgetown University School of Foreign Service and a master's degree in economics from Cambridge University. He graduated magna cum laude from Harvard Law School, where he is the Supreme Court editor of the Harvard Law Review. Following graduation, Mr. Clement clerked for Justice Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit and for Associate Justice Scalia of the U.S. Supreme Court. After his clerkships, he worked with an associate in the Washington, D.C. office of Kirkland & Ellis. Mr. Clement went on to serve as Chief Counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights. Afterwards, he was a partner in the Washington, D.C. office of King & Spalding, where he headed the firm's appellate practice. Mr. Clement also served from 1998 to 2004 as an adjunct professor at Georgetown University Law Center, where he taught a seminar on the separation of powers. Mr. Clement joined the Department of Justice in February of 2001. Before his confirmation as Solicitor General, he served as acting Solicitor General for nearly a year and as Principal Deputy Solicitor General. He has argued over 40 cases before the United States Supreme Court, including District of Columbia v. Heller, the D.C. gun ban case heard by the Supreme Court today. Also serving as a justice this evening is the Honorable D. Brooks Smith of the United States Court of Appeals for the Third Circuit. President George W. Bush nominated Judge Smith in September 2001, and he was confirmed by the Senate the following July. The court serves Pennsylvania, New Jersey, Delaware, and the U.S. Virgin Islands. Judge Smith is a member of the American Law Institute, as well as the Federal Judges Association. He served on the U.S. Judicial Conference's Criminal Rules Advisory Committee for 6 years and recently was appointed by Chief Justice John Roberts to the conference's Committee on Space and Facilities. Judge Smith has traveled to countries throughout Central and Eastern Europe to teach in judicial training sessions to enhance the rule of law. Judge Smith is a graduate of Franklin and Marshall College and received his law degree from the Dickinson School of Law. Prior to his appointment to the federal bench, he practiced law, served as a district attorney, and sat on the state bench in Pennsylvania. He has been a member of many boards and trustees for nonprofit organizations, including those of Institutes of Higher Learning. And then our final judge this evening is the Honorable Brett M. Kavanaugh. Judge Kavanaugh was appointed to the U.S. Court of Appeals for the District of Columbia Circuit on May 30th, 2006. Judge Kavanaugh received a B.A. cum laude from the Yale College in 1987 and a J.D. from Yale Law School in 1990. He began his legal career as a law clerk to Judge Walter Stapleton of the U.S. Court of Appeals for the Third Circuit, and then clerked for Judge Alice Kaczynski of the U.S. Court of Appeals for the Ninth Circuit. During the 1993 term, Judge Kavanaugh was a law clerk to Associate Justice Anthony Kennedy of the U.S. Supreme Court. Prior to his Supreme Court clerkship, he served for 1 year as an attorney with the Office of the Solicitor General of the United States. From 1994 to 1998, Judge Kavanaugh was an associate counsel in the Office of Independent Counsel, after which he was a partner at Kirkland & Ellis. From 2001 to 2003, Judge Kavanaugh served as associate counsel and then as senior associate counsel to the president. From July 2003 until his appointment to the court, he was assistant to the president and staff secretary to President Bush. Thank you for bearing with me. Competitors, good luck, and please enjoy the evening.
All rise. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We are here this evening to hear the case of ABC School District versus James A. Parker. Is the petitioner ready? Ms. Brookover? You may start anytime you're ready.
Mr. Chief Justice, may it please the court. My name is Laura Brookover, and I and my co-counsel, Jeffrey Hantson, are representing the petitioner in the case of ABC School District versus Parker. I will provide an introduction to the case and analysis of the coercion test, and my co-counsel will address the endorsement and lemon tests. Would you like a recitation of the facts?
I believe that the court's familiar with the facts. You may start your argument immediately.
The issue before the court is whether ABC School District's policy of requiring teachers to lead willing students in daily recitations of the Pledge of Allegiance violates the Establishment Clause of the First Amendment. It does not, and the lower court's decision should be overturned for two principal reasons. First, the Establishment Clause does not require that government censor all references to religion from civic discourse, and the reference to God in the pledge does not rise to the level of coercion. Additionally, the reference to God in the pledge does not render it a religious exercise. The pledge policy passes the coercion test, as set forth in Lee v. Weissman. Lee considered whether a high school's practice of inviting members of the clergy to give prayers at graduation exercises was a violation of the Establishment Clause. The court first asked whether students felt pressure to participate in the prayer, and additionally, whether students had an opportunity to meaningfully display dissent. In that instance, because a prayer merely requires passive attendance for students to show participation, there was no opportunity for dissenting students to show that they were not participating by standing and remaining silent. In our
Also,
case,
what do we mean by religion? Could you define what religion is?
religion is a set of beliefs which an individual has with reference to spiritual beings or a spiritual life outside of the physical being.
So if I believe in a tree or the sun or another person who's living or dead, does that make it a religious definition?
No, it does not. If you believe in scientific facts, that is distinguishable from religious beliefs which have their foundational basis in faith.
Does it have to be faith-based?
Generally, it is faith-based when speaking about religions. I'm not familiar about every religion there is, but generally it is a belief inside oneself that is separate from facts and science.
Well, surely you would distinguish a tree from God, for example. So to get to the heart of the case, why isn't the reference to under God a religious reference and one that is based in the state's establishment given the nature of this statute and policy?
The reference to God, as analogous to other references in civic discourse to God, has acquired a sense of ceremonial deism, as Justice Brennan put it in his dissent in Lynch. The references to God merely acknowledge that historically our framers did believe in a God, and that they mention this God in such things as the Declaration of Independence. The reference to God today merely has a ceremonial formalizing aspect, and it is that aspect that it gives lens to the Pledge of Allegiance.
Go ahead.
I'm sorry. May I take you back to your references to Lee? Is Lee the paradigm? Is Lee the test that we ought to apply here?
You may apply Lee here, which is the coercion test.
Well, I know we may, but you began your argument by reference to it, several references to it.
Well, the coercion test is uniquely suited to a classroom setting. In that case, it was a school-sponsored event.
Well, exactly. So isn't this case really similar to Lee in the sense that the children are going to feel pressured to stand and to participate when the pledge is recited?
Yes, Justice Smith. It is similar in the sense that children in our case do feel pressure from their peers to conform in the recitation of the pledge. However, it's different for a number of reasons. In that case, the issue was whether a prayer was a violation of the Constitution. In this case, it's whether a pledge is a violation. Also, the pledge is led by a teacher who is clearly...
Well, let me stop you there. Why is that better? Why is it better to not just have a prayer, but to conjoin God with a pledge of allegiance to the flag of the nation when what we're interpreting is an establishment clause? Why is that better?
Your Honor, it is better because the pledge is primarily a patriotic exercise, whereas a prayer is inherently a religious exercise.
Great. So at least if it's inherently religious, it might be separate. But here, this is absolutely conjoined. Look at the flag and talk about God.
Yes, Your Honor. And in other cases, the court found that while government might make religious references, there can be mitigating circumstances. For instance, in County of Allegheny versus ACLU, the court found that a menorah, when displayed with a Christmas tree and a sign that said "Salute to Liberty," did not violate the Constitution because of the other symbolic references around it.
But here you have it's a profound statement of religious belief. It's not something where you're trying to disguise it or mix it up with other issues. It's a profound statement of belief that is a statement of religious belief.
Your Honor, it is a reference to the Founding Fathers' belief. It is not a profound statement.
You don't think it's a reference to what people believe today?
It is not a reference. People do believe today in a God, but as the under God is incorporated.
And when you're saying the Pledge of Allegiance today, isn't that a statement not just about the nation's history, but that today, when you say the Pledge of Allegiance, you're saying that it's a nation under God today?
When a student is reciting the Pledge of Allegiance, he is reciting allegiance to a flag. And in the contents
It's in
of
the
pledge,
present tense, isn't it?
Yes, Your Honor, it is in the present.
Well, but isn't also, if you're talking about history, this isn't the Declaration of Independence or the Gettysburg Address. Instead, it went into the pledge for the precise purpose of having the American people affirm a dedication to the Almighty. That seems to me to be a religious purpose in terms of putting it in the pledge in the 1950s?
Your Honor, it is different from historical documents, but we do have other instances in civic discourse where people presently affirm an allegiance. For instance, when witnesses are sworn in before courtroom testimony, they are asked to place their hand over the Bible and give an oath. And that is also an affirmation. It is also an optional...
Wasn't the whole point where I think that Justice Smith took you back to in Lee is the whole coercive nature and what's talked about in Lee, and which was also in the predecessor situation of Barrett, was that subtle coercion, because these are school children. These are not adults. And you really haven't given us, I don't think yet, an answer as to why, as to school children, this is not a declaration or an affirmation of faith. Could you respond to that?
Your Honor, school children, like other individuals reciting the pledge, understand that under God is a reference, a historical reference, and it also serves...
So like a kindergartner, for example, might stand up and say, no problem, this kind of reminds me of the Declaration of Independence. I mean, so I'm having a little trouble understanding why they would divine that if they were in preschool or in first grade, for example.
Your Honor, children do face other references to God in other areas. For example, we have "In God We Trust" on our currency. School children are forced to grapple with this blending somewhat of religious terminology in civic discourse at a young age. And in fact, reciting the Pledge of Allegiance in a classroom gives school children the opportunity to become accustomed to that in a secular setting, in an informational setting, and in a setting where they can ask questions.
Now, from a historical perspective, the phrase "under God" was only included in 1954, so from a historical perspective, it's only been there for about 53 years.
Yes, Your Honor,
How
that's
could
right.
that be history when the original Pledge of Allegiance did not have the phrase "under God"?
Well, Your Honor, the original Pledge of Allegiance was only codified about 10 years before "under God" was added. So the age of the Pledge of Allegiance itself is about 60 years old. But the fact that it has been used almost uniformly across the country as the premier expression of patriotism, and through its rote recitation, the "under God" has been subsumed into a primary message of patriotic expression.
Do you think Congress could add something to the Pledge of Allegiance at the end that says something, and we also pray that God bless America?
No, Your Honor. I do not believe that Congress could add the words "we pray, God bless America." I think "God bless America" on its own would be acceptable.
We ask that God bless America?
Yes, Your Honor, I think that would be acceptable. There are other instances of "God bless America" being used in civic discourse. We have a patriotic song that begins "God bless America." We have presidents in their inaugural addresses continually asking God to bless America. And these examples show that individuals and children are able to discern that references...
The Court's drawn a very bright line, as my colleagues have noted, between those ceremonial instances and every day in the classroom being taught. If this were before every class, if the pledge were said before every class, would that matter?
No, it would not, Your Honor. If the policy that the school district promulgated for patriotic purposes specified that students recite the Pledge of Allegiance before every class, that would serve the purpose of expressing patriotism. And thus, it would not send a message that the government is intending to establish a national religion.
How about if it said "under Jesus"? Would that matter?
Under Jesus, Your Honor, would make a difference because there isn't a history of under Jesus in civic discourse. Under God, as it stands in the pledge, simply pays homage to the founders and their religious beliefs.
Okay, so just so I have your answer, you said it made a difference. Does
Yes,
it make a
it does.
dispositive difference? Is that an unconstitutional exercise?
Yes, Your Honor, it is an unconstitutional exercise. Again,
How
a
do you
reference...
know that Barrett said that the pledge was really characterized as declaring a belief? And that seems to me, that language is at odds with how you characterize the pledge. Has something happened since the Supreme Court made the statement there?
Well, if you are referring to Barnett, the words "under God" have been added since that decision.
Right.
And under God, as it...
But even then, the pledge was viewed as a declaration and the salute. There was a salute, correct?
Yes, Your Honor. But at its essence, the pledge is an allegiance to a flag. It is not an allegiance to a religious figure. And the notion that we are one nation under God is a notion that has its roots centuries ago, and it is merely a descriptive add-on.
Does it make any difference if the pledge was required in a baseball game instead of the song that we normally sing, the Star Spangled Banner, or at the beginning of the game? Would it make a difference?
Your Honor, there would make a difference if it was a government-sponsored event. If the government were sponsoring the recitation of the Pledge of Allegiance at a baseball game, in fact, it would still be constitutional, because the meaning of under God within the pledge does not change based on age, and it does not change based on setting.
Does it change based on location? Because this is a school where the students are required to attend, where you're not required to attend a baseball game.
Yes, Your Honor, that is true. And because students are required to attend and face the recitation of the Pledge of Allegiance daily, they are given the opportunity to reflect on its meaning. They have the opportunity to speak with their teachers if they want and to express their dissent to the pledge, and they can ask their parents as well. So the ongoing nature of the pledge serves to open up to students the issues of government references to religion and what those might mean and how they choose to react to them.
You have seemed to rely to a great extent upon the historical use in formative American documents and otherwise on references to God. Am I correct?
Yes, Your Honor.
Am I mischaracterizing your argument? With that in mind, are you suggesting, and I refer to the earlier question from my colleague about whether or not it would matter if it were under Jesus,
Yes, Your Honor.
are you suggesting that the use throughout history up to now of the term under God has somehow, even if originally intended to invoke some spirituality or reference to God, has somehow now been denuded of any kind of religiosity? Is that part of your argument, or am I misreading it?
Yes, Your Honor, that is part of the argument. And the court has shown inclination in the past to heavily consider aspects of history and tradition. For example, in Marsh v. Chambers, the court held that legislative prayer, whereby chaplains paid by the public coffers led opening sessions in prayer, was constitutional because of the long-standing history and tradition surrounding the practice.
If this case had been brought in 1955, right after under God was added to the pledge, would you have a different position?
No, I don't, Your Honor. This case asks merely whether the ABC School District's pledge policy violates the Constitution. And the pledge policy serves a patriotic purpose. The recitation of the Pledge of Allegiance is a chance for students to express their patriotism.
I believe your time is up. Any more questions from the panel? Thank you.
Thank you.
I think she has some additional time.
45 seconds.
45 seconds? I'm sorry. I thought it was 0.
In closing, because the pledge with Under God has been used for decades now by school children across the country as the premier example of patriotism, and because Under God, as it has been used in other areas of civic discourse, has been found by the court to be constitutional and to be primarily secular in meaning, the court should overturn the lower court today and affirm and find that the pledge policy is constitutional.
Thank you, Ms. Brookover. For the respondent, who will be arguing next? Are you going to argue for the petitioner? I thought you were splitting. Okay. Whenever you're ready, Mr. Hantson.
Mr. Chief Justice, may it please the court. My name is Jeffrey Hantson, and I represent the petitioner in this matter, ABC School District. In an effort to instill patriotic virtue in its students, ABC School District requires its teachers to lead willing participants in a recitation of the Pledge of Allegiance. Excuse me. Whether viewed through the eyes of the district or an objective observer, the district's policy has a clear purpose of promoting and endorsing a love of country, not religion. Furthermore, because the district utilizes the federally codified Pledge of Allegiance to reach its goal, it ensures that there will be no entanglement between the district and any religious organization. Therefore, the ABC School District policy that requires teachers to lead willing students in a recitation of the Pledge of Allegiance satisfies the Establishment Clause test established by this court in Lemon and Lynch. The establishment...
Well, let me just stop you there. I mean, I have a little trouble understanding lemon and all its various prongs and prongs that have been collapsed and recollapsed. So let me just ask a simpler question for me, which is, I just look at the Establishment Clause, and I say that it appears that what violates the Establishment Clause in particular, as an originalist matter, is the creation of an official state church. And from that originalist perspective, what could be worse than asking students to look at the flag, maybe put their hand over their heart, and conjoin the concept of the nation and their allegiance to the nation and their allegiance to being a nation under God?
From an originalist perspective, the framers of the Constitution recognized that ceremonial invocations of God will be accepted. The very week that the First Amendment was drafted and sent to the states for ratification, two particular pieces of legislation were passed. One, appointed and funded chaplains for each house of Congress. The second piece of legislation called on the president to acknowledge through Thanksgiving an acknowledgement of the Almighty and all that He has given America.
Okay, but let's take the first tradition for a second, which is, I mean, okay, Marsh v. Chambers, and we know that legislative prayers are okay. But would you take the position that I don't know if your state has a state chaplain, but let's assume for purposes that there is, consistent with Marsh v. Chamber. What if the patriotic exercise was every morning the students would hear a recitation of the prayer that was read in the State House the day before? Would that be constitutional?
That would not be constitutional. The court has recognized, particularly in Engel v. Vitale, the particular religious aspect of prayer that is separate from the Pledge of Allegiance. The court pointed...
Okay, but doesn't that also suggest that schools are different?
It does. It certainly does suggest that schools are different, and that's how the court was able to distinguish from Marsh v. Chambers. However, in Engel, they recognized that in school they were not separating and preventing the recitation of whether it be religious documents, whether it be other patriotic exercises, such as my co-counsel discussed, God Bless America, the Declaration of Independence, which calls forth God, the Almighty, protection of providence.
How are you defining prayer?
Prayer in particular it's a sublimation of calling forth your belief in a God and the belief in something that is outside yourself. In the Pledge of Allegiance,
calling forth, what do you mean by calling forth?
Call it a recognition that there is a power outside of the natural world and calling forth on that power.
Well, that's a precondition to prayer, isn't it? Otherwise, it's kind of a soliloquy.
Absolutely. So within that, in order to set forth and perform a prayer, a person would have that inherently religious nature already. But through that prayer, they are calling forth on that belief that they have, whether it be God or whether it be something outside of that, in order to, whether it be look over them or guide them in the future.
Well, I'm not trying to put words in your mouth, but isn't a prayer a supplication, essentially?
Yes, that is a
So how does that compare to the pledge here?
The pledge itself is not a supplication. It is a reference to what the country is, what this country is, the flag of this country, what it represents, which is the country and what it historically is, and then finally what this country stands for.
But you're not resting your argument on the premise that if it's not a prayer and you're invoking God, that it somehow is beyond the Establishment Clause, are you?
Certainly not. I was simply referencing how a prayer is separate from the pledge. The pledge is...
But isn't the pledge, I mean, go back, what was the purpose that Congress set forth in inserting God into the pledge?
That, unfortunately, is not within the record. What we have is a signing statement of President Eisenhower that recognized that this is to be an affirmation that this nation is a nation that recognizes the Almighty. However, President Eisenhower was not a legislator. He was not one of the individuals who drafted this legislation.
Well, I assume he also wasn't a member of your school board. What is the relevancy to this signing statement and this policy of this school district?
There is no relevance to the signing statement, and that was what I was getting to. The school board itself put forth this policy of having its teachers recite the Pledge of Allegiance in an effort to meet the new Columbia School Code that saw an appropriate patriotic exercise. An objective observer, which is what the court has pointed to in Lynch and County of Allegheny in particular, would clearly recognize the recitation of the Pledge of Allegiance as a patriotic exercise. Whether they looked at the phrase "under God" at all is a question for those individuals, but an objective observer could recognize that phrase "under God" as a secular nature, the secular nature of that phrase.
What if that phrase was taken?
You must have said something that
I guess so.
prompted a response.
What if that phrase were taken out of the Pledge of Allegiance? Under God, would that still be a patriotic exercise?
It certainly could be.
Well, it was for 10 years.
That is true, and I guess I would have to address that separately of whether it was Congress who removed "under God" from the pledge or whether it was the school district itself. The court recognized in Lynch that removal of all recognition of religion and God in our civic society could itself be a violation of the Establishment Clause. If the school district went forth and removed...
Wait a second. I mean, we might have said that in a wild fancy of dictum, but we don't have any cases that actually suggest that, do we?
That is true. I'm simply pointing out a reference that the court made in Lynch. And to show that if the school district were to itself instruct its teachers to recite the pledge without the phrase "under God," they would then be taking a position on religion. By removing that phrase, they would be saying that those who do not recognize a God are more important than those who do, as opposed to simply taking the federally codified pledge and using it as the patriotic exercise that they seek to do today.
Well, under the Lemon test, whatever is left of it, you have to look there. You do look to whether it's a secular purpose. So the question is, your worthy colleagues on the other side would say, well, you looked at the signing statement or whatever in terms of the dedication to the Almighty. Are you taking the position that really we look to the school board policy rather than to the policy behind the pledge?
The policy that is at question today is the school board policy, and we should look to the purpose, the secular purpose of that policy, which is a patriotic exercise. However, because it uses the federally codified pledge, it does make sense to walk your way back to the codification of the pledge.
You have frequently referred to a federally codified pledge. Are you suggesting that what is important for your position here, may be pivotal for your position, is that it is simply some kind of sterile enactment of Congress and therefore the words themselves don't matter? And is this no different than if what the school board had required is that the students recite some arcane provision of ERISA every morning, which would be a hell of a way to begin the day. But
I would have to say, I'm glad that the school board did not decide to do that. But I would also say that it does matter to an extent that the federal government recognized the pledge as it is codified as an appropriate exercise of patriotism. And the school board putting forth that same rationale and using the pledge shows that they are recognizing as the federal government did, that the pledge is an appropriate patriotic exercise. They could use something different. And that something different could also include the word God. They could have their children sing "God Bless America." They could have their children sing the Star-Spangled Banner. From the perspective of an objective observer, they would recognize these as patriotic exercises, not an establishment religion or forcing religion upon these individual students.
Could they be forced to face the flag and say, "In God we trust"?
That would certainly be an appropriate patriotic exercise.
Really? You think that they could force the students? I realize they could opt out. They could opt out, fine. But you think it would be an appropriate patriotic exercise to just face the flag and say, "In God we trust"?
As long as it was a voluntary exercise. I missed your word "force," unfortunately. But as long as it was a voluntary exercise, yes, the "In God We Trust" has been recognized as our national motto. It has been put on our currency. It is pervasive in American life. And because of that, the ubiquitous nature of that phrase, it has lost much, if not all, of its religious meaning. So to face the flag...
Where do we look? Where do we look to find when something's sort of fallen out of circulation as actually having any religious content?
It's not a clear line, unfortunately. I wish
knew that.
Yes.
Well, it's really an insulting line to suggest that the people who are saying the Pledge of Allegiance now, or the people who say "In God We Trust," really doesn't mean anything to them.
To some, I'm not saying to all people it does not. What I'm saying is that
your argument seems to be to minimize the significance of it so much that when in fact the purpose of it originally, and to many of the people who say it still, in God we trust, under God, is very much religious, as Justice Clement pointed out, to conjoin the state and the belief in God.
And to many people, that is absolutely true. But with things such as the Pledge of Allegiance, the national motto, what people recognize, what a vast number of Americans recognize, is the patriotic nature of those activities, the patriotic nature of those words, rather than the particular religious meaning that's involved with the phrase, in God we trust, or under God.
So you really
when
would
does it
have us
become-
adopt a de minimis test, in other words? In other words, so as not to do any harm to Justice Kavanaugh's following on those who might be offended. For the others, you say it's just de minimis. The rest of you can believe religiously, but in order to sustain it constitutionally, you're asking us to adopt a de minimis standard.
Not really. I was merely recognizing that the rote repetition of the pledge, or in God we trust, has led to a lack of religious meaning in those phrases.
So in other words, the rule we would adopt would be, if it becomes a mantra, then it would be constitutional. Would that work?
I guess I don't quite understand.
Well, you said it's a rote recitation. I mean, Hail Mary sometimes for some people is a rote recitation, I would imagine. But so you're kind of, I'm saying, if I heard your last statement right, rote recitation, which I say is kind of equivalent to a mantra, that could give us a bright line in your view.
It could. What I'm saying in this case is, as we're asked to look at individuals and how a religious individual or how a non-religious individual would look at that, is not what the court has done. They have not taken that subjective approach to the individual.
So is your point that this doesn't even reach de minimis?
I would argue that at most it reaches de minimis. And I would argue that there is a position that it does not even reach de minimis.
And so what will be the test so we'll know what flies under the radar to be less than de minimis?
What the court should recognize, going all the way back to the founding of this country, is what references to God are purely ceremonial in nature versus what are religious in nature. In determining that, you must look at the context in which they are used, as the court has done throughout its Establishment Clause jurisprudence. The County of Allegheny case was brought up where a nativity that stood on its own was found to be unconstitutional, as opposed to a menorah that was within a holiday display was completely constitutional. The phrase under God within the Pledge of Allegiance.
Could they add God
how
save
do we
the
know
United
when-
States? Sorry.
Go ahead.
Could they add God save the United States at the end?
That's a difficult question. I would say
Ceremonial?
I would say that it is
Seems rote, repetition.
It does,
Yeah.
and I would say that is an acceptable addition to the Pledge of Allegiance.
What do you mean?
If we could make it in that little context where we had the creche and the menorah and everything, so then could we say one nation under God, under Jesus, under Allah, under Buddha, and any other deity one might want to add? Would that be acceptable then, to bring you in with your County of Allegheny allegory?
No, it would not. The court in County of Allegheny said, referencing a Christian religion as well as a Judaic religion is no less can be no less unconstitutional than just referencing one. May I finish my point,
Yes,
please,
you
Mr.
can.
Chief Justice? If within the Pledge of Allegiance, the school district decided to add under God, under Jesus, under Buddha, under whatever other God they may choose to do in an attempt to make it all encompassing, they would be specifically addressing a religious aspect and therefore would be establishing religion under the First Amendment. Because they simply address under God as it is codified and as it has been utilized, it does not violate the Establishment Clause of the First Amendment.
Thank you,
very
Mr.
much for your
Hantson.
time.
Thank you.
Who will be up first?
I will, Your Honor.
Mr. Meltzer? Whenever you're ready.
Mr. Chief Justice, may it please the court. My name is Ari Meltzer, and along with my co-counsel Ryan Creighton, I represent the respondent, James A. Parker, in this matter. I will be addressing the coercion test. My co-counsel will address the endorsement test. Your Honors, this is a case about the custodial role of public schools and the importance of protecting the religious expression within that setting. Now, this court, as has been recognized today, has promulgated 3 tests for evaluating the Establishment Clause, the violation of only one of which is required for you to find the action in question to be unconstitutional. You should affirm the decision of the 13th Circuit for 2 main reasons today. First, the policy of having teachers lead the repetition, the daily recitation of the Pledge of Allegiance in their public school classrooms is a coercion of religious expression among the students in that setting
But the
who are
students
especially
are free not to participate.
Your Honor,
They're
that is
not required to participate. There's no mandate that they participate. They're free not to participate. Why is that coercion?
Mr. Chief Justice, that's correct, but you have a state-run teacher who's gotten that authoritative figure in that setting. This is a custodial person who's replicating the role of a parent in that setting, but also the machinery of the state in that setting.
Yes, but what are they coerced to do? Coercion's a very loaded term. What are they coerced to do?
Your Honor, what they're being coerced to do is to express religion or to participate in the expression of religion. Within that setting, there's really 2 levels of coercion. The first level of coercion is coming from the teacher, from the person who's representing the authoritative figure and representing the state. The second level of coercion, also recognized in Lee, is the coercion among the peers, requiring a student within that protected setting of a public school to make the decision whether they want to participate doing the same thing that the rest of their peers are doing, or whether they want to be the one to stand up and say, I disagree with this, I'm not going to participate, I'm going to be the loner within this classroom setting.
But the opt-out is, we know from Barnett, is good enough for one part of the First Amendment, the coerced speech, free speech part. Why would it not be good enough for another clause within the same constitutional provision?
Well, Your Honor, as you recognize, in Barnett it was talking about the free exercise element of the First Amendment and not the Establishment Clause. And the distinction between that is that the Establishment Clause is dealing with a negative right. It's prohibiting the state from taking a certain action, whereas the free exercise is actually protecting an affirmative right of the people. And that negative right deserves a much greater protection than that affirmative right. The coercive setting is much different when it's dealing with the right of the state, that negative right not to promote religion, not to endorse religion, as opposed to interfering with the free exercise of religion.
Well, let me ask you, when you were a school child, were you required to learn the Gettysburg Address?
I would imagine at some point I was.
Okay. And most children are, and they talk about this nation under God. So, and that's, you would agree that that's basically one of our nation's historical documents, right?
Yes, Your Honor.
So would it be constitutional in your view if the students recited the Gettysburg Address every day?
Your Honor, it falls to the context. The answer is yes, within the appropriate context.
Okay, so now this statute, as I understand it, says you need to have some kind of patriotism every day. And then they say, of course, the pledge also qualifies. So let's say the teacher doesn't like the pledge. She loves the Gettysburg Address. So every day we do the Gettysburg Address. Constitutional or not constitutional?
Constitutional, Your Honor. The key distinction between the Gettysburg Address and the Pledge of Allegiance in this setting is the affirmation, the words, I pledge allegiance, where when a school child is making that statement, they're endorsing the normative views, which is what Barnett recognized that the Pledge of Allegiance is. It's a series of normative views about the state of our country and since 1954 about a belief in monotheism and the role of God and religion. So whereas the example that you give with the Gettysburg Address, they would be reciting a historical statement and reciting the words of, the words of the author.
But what about the Supreme Court then said in Ingalls that things like that we think of as kind of patriotic songs, that those were actually professions of faith that seemed to, according to the court in Ingalls, be just fine. And if singing a song is a profession of faith and that's okay, or at least they alluded to the fact that that would be okay, what would be the difference between a profession of faith in a song, because you sing it, and one where you just put your hand over your heart?
Well, Your Honor, it's interesting because in Engle, the one key thing that's missing within that whole paragraph about what's acceptable is the Pledge of Allegiance, despite its role in almost every other case talking about the subject. And what Engel does say...
What year was Engel decided?
Engel was decided while the Pledge of Allegiance was established
62.
in 62. So it was after the words under God were added.
Mm-hmm.
And the key, what Engel does say is appropriate is it says there's two things that are appropriate within the ceremonial context. The first is historical reference, which would address the Gettysburg Address example. And the second thing that's appropriate is a practice of speech where it's reciting in song the beliefs of the composer as opposed to the beliefs of the individual. Where the Pledge of Allegiance is different from that is it's actually it's the words of the individual who's reciting it.
So it's the first three words of the pledge that really are problematic for you. Is that it?
Yes, Your Honor. It's those.
That's what separates it from the Declaration of Independence or recitation of the Declaration with its various references to God, and likewise the Gettysburg Address.
Yes, Your Honor. That's an important distinction, is that it's the affirmation by the individual of that belief in those normative values.
I suppose it's really only the first word, right? I mean, if they had to say he pledges allegiance, it would be okay?
Yes, Your Honor, that would be a key distinction when you're talking about somebody else's views or a historical view as opposed to an individual's view. And that's where the expression really becomes coercive, when a student is being put in the position of either saying, this is what I believe, or being the one to say, I don't believe the same thing as everybody else. And in the setting of an elementary school classroom like Ms. Parker is in, that's an awful choice to put that student in the position of saying, and more often than not, that student is going to choose to go along with the majority, which is what creates the coercive setting and the establishment of religion through that coercion.
Does age have a difference? What happens if it's done at a high school level? Does that make any difference?
Well, Your Honor, no, it does not. The court has recognized a distinction between elementary and secondary schools and between adults. Now, where would you draw that line? Is there a 17-year-old who might be responsible enough? Perhaps.
Some 17-year-olds I know are not responsible.
Absolutely. And you have to look at the reasonable observer, and is there a chance that a reasonable observer in that setting is going to feel coerced by that speech?
Well, part of the...
Would that be...
Go ahead.
Would that be a determination, a line that we can draw as to whether or not the Pledge of Allegiance recited by 10-year-olds in kindergarten or grammar school would make a difference in high school, secondary schools?
Well, Your Honor, this court has long recognized in Marsh and in Lee and in other cases the distinction between primary and secondary schools and other settings, and I don't see any reason to change that precedent, to change that standard between primary and secondary schools.
So we should continue that distinction?
Between saying primary and secondary schools deserve different protection from the adult setting, yes, Your Honor.
Your case really seems to depend on the idea that coercion means impermissible coercion, even though the student's not required to say anything. And in Lee versus Weissman, where the court adopted that kind of approach, the court placed special emphasis on the idea that it was a formal religious exercise. That phrase appears a couple times in the court's opinion. There was a clergy member who led the prayer in that case. That seems quite a bit different. There's no formal religious exercise here. So why should we take that special coercion, what the dissent called psychological coercion, and import it into this context?
Well, Your Honor, it goes to the reason behind the test in the first place, which is the Establishment Clause and the prohibition against a state establishment of religion. And in this setting, where you have an affirmation of the monotheistic
do you think it's a problem that the students can use money?
No, Your Honor.
Why not?
Well, first of all, when a student uses money, that the student is not endorsing the words "In God We Trust" on the money. I don't think any reasonable observer, when there's an exchange of money, interprets that as an endorsement of the values that are stated on the money. They endorse it. They see that as an endorsement of the value behind the money, that a dollar is a dollar, no matter what it says on the dollar bill.
Why did you switch gears to endorsement, though? I thought we were talking coercion. I mean, aren't we all coerced to use the money that says "In God We Trust"? We don't even get to opt out of that.
That's true, Your Honor, but we are not coerced to endorse that view. We are not coerced to make that affirmation of "I pledge allegiance to In God We Trust." I pledge allegiance.
Who's the we?
I'm sorry, who's the we in what setting?
In God We Trust. Who's the we?
It's we as a nation. It's we as a national model. It's not an individual saying, I specifically believe in God and support God.
I'm not part of the
If we
we.
say we pledge allegiance to the flag, does that fix it?
No, Your Honor. In that setting, it doesn't, because the we then becomes inclusive of the person who's saying we, whereas we, in a context where it's printed on money and not specifically affirmed by the person who's using that money, in that setting, it's not an endorsement of the value. It's a very specific setting with the Pledge of Allegiance. I pledge allegiance, or even we pledge allegiance. It's that person respecting the normative value that's included. Even if you look to the dissent in Lee, to Justice Scalia's dissent, where he in that case was supporting the pledge, he made the distinction in that setting of saying, both because it was a voluntary setting, unlike a school setting where a student is forced to participate, where a student is forced to go to school, that it becomes more coercive for the Pledge of Allegiance in a setting than it does to have an invocation before.
Again, it's not a formal religious exercise, this saying of the pledge, which was the key fact that Justice Kennedy put emphasis on.
Well, Your Honor, it's not a formal religious exercise, but it is a religious exercise. And
well,
again,
he was quite careful in his majority opinion in Lee multiple times to use the words formal religious exercise.
Your Honor, there was a frequent reference to religious exercise, as there has been in all of the case law regarding both this case, regarding both this issue and all issues of the Establishment Clause. Religious exercise is the common refrain, really, in those cases. But what's also important, again, is to go back to the whole purpose of the Establishment Clause and what we're trying to protect. The whole reasoning behind the Establishment Clause is to protect a state establishment of religion. And in the case where you're forcing somebody to choose between saying, I believe in no religious value, or I believe in religion, that is an endorsement of religion. That is an establishment of religion.
What is ceremonial deism, which is referenced in Lynch and alluded to with different words in other cases? And it's implied by the court, certainly, that if something falls in that box, it would be permissible. Does the pledge fall in that box?
Your Honor, the pledge does not fall into that box, because ceremonial deism falls within a setting, again, where there's no affirmation of the values that are required. Something like In God We Trust on money would be a ceremonial deism in the sense, under that recognition, which has not been endorsed in many of the cases. But the ceremonial deism is situations where there is a state recognition of a value, but not necessarily one that's impounded upon or forced upon the actual citizens of the state.
But I'm curious about forced upon, because you're not forced to say it, you're forced to be exposed to it. And that's true with the money, that's true with the presidential proclamations, that's true with inaugural addresses. It's the same kind of exposure to a stated national belief in religion in all instances there. So you keep using the word affirmation, but the student in question is actually not affirming anything.
Well, Your Honor, that's where the coercion of the setting comes in. And the fact that you've got the two versions of coercion, when a state-paid teacher in a state-run classroom is leading the class in a recitation of the Pledge of Allegiance. In that setting, there's no reason why a student, certainly there are students who would interpret that as the machinery of the state promoting those values, in which case, if they feel the need to participate, either through the fact that the authority figure is promoting those values, or because the other students around them are participating in those values, that's a forced establishment of religion as much as it would be to require them to make those statements. And in fact, in some cases, it's even worse because it's a subtle coercion where they don't know that they're being forced into that mindset and they don't recognize that there's a choice to be made.
I don't really understand how you get from the kind of, we know we don't have real coercion here because they can opt out. So we're talking about some sort of amorphous psychological coercion. And as to that, why does the pledge aspect of it matter? When you just talked about what was coercing them, it was the teacher, it was the fellow students. What makes it more problematic, as you suggested earlier, that those factors combine with I pledge allegiance? I don't quite understand that.
Well, Your Honor, the question is what they're being coerced to do. Are they being coerced into religious exercise? And in this case, where there's a setting where both the state machinery and where the students around them being supported by the state machinery that's been put into place.
Okay, but why does I pledge make it more of a religious exercise? If anything, it seems to make it less because it seems to direct all the attention to the flag, not to the God part.
Well, Your Honor, in Barnett, the court recognized that there's a normative value to the Pledge of Allegiance. Admittedly, that was before the words under God were added, but it's still the same situation. May I finish my answer?
Yes.
the situation still remains the same, and the analysis remains the same, that there's a normative value that I pledge allegiance to the flag of the United States of America and to the Republic. This is all normative values endorsing what the flag stands for, including the monotheistic view that we are one nation under God. And for those reasons, the coercive effect, I urge you to affirm the decision of the 13th Circuit.
Thank you, Mr. Meltzer. Mr. Creighton?
May it please the Court. My name is Ryan Creighton, and I am also representing the respondent in this case, James A. Parker, in this case with respect to the endorsement test of the Establishment Clause. The Pledge of Allegiance is a state endorsement of a specific religious activity that in this case is directed towards our nation's most impressionable citizens, its school children. This Court has recognized in cases that there is an impermissible endorsement by the state of a possibly religious activity when that activity conveys a message that the state is preferring or favoring a specific religious belief. Now, such a preference is present in this case for several reasons. The first is that a reasonable observer, which is the test that was established by this Court in Engel v. Vital, would understand the words "under God" in the Pledge of Allegiance to indicate a direct affirmation of a specific religious belief, in this case, monotheism. The second reason is simply that in this case, as my co-counsel addressed, Barnett held that every term within the within the Pledge of Allegiance is an actual normative statement. And in that case, a student who is listening or even partaking in the Pledge of Allegiance is more likely to believe that the state is endorsing that statement. The statute here requires that the teacher lead the students in the Pledge of Allegiance. And any reasonable observer who was listening to their teacher say the words, "I pledge allegiance," followed by "to this nation under God," would then follow with that reasonable belief that in this situation, the state is endorsing that religious belief. The third reason that I will be discussing
Which
is...
aspect of the state matters here? Because, I don't know what happened in 1954. I guess we don't have the legislative history in the record. But it seems like if the relevant focus is this school district, there's a much better argument that they weren't trying to endorse anything. They were just trying to comply with this requirement.
Your Honor, there's a possible argument that the school district here was not necessarily intending to endorse religion. However, this court in McCreary held that in terms of the purpose prong of the endorsement test, you should look at the entire legislative history and not merely to, say, the most recent statute that created the activity in question. In this situation, the 1954 signing statement stated specifically that there was a religious purpose behind...
Sure, but unless I'm forgetting McCreary, I mean, it seems to me that there was only one level of government that was relevant there. It was all at the county commission or whatever it was. And so you didn't have this problem that we have here, that you have one local school district that's incorporating something that's on a national level that's 50 years earlier. So, I mean, in that context, do you still think you just smush it all together? Is that?
Your Honor, I still believe that in that context it should be a factor. The school district knew what it was adopting as the full codified Pledge of Allegiance and knew the legislative history.
Well, that does not imply, however, that they knew the legislative history, does it?
Not necessarily, Your Honor. However, the overall test of endorsement is what the reasonable effect is going to be, and purpose informs that effect.
But the purpose, the stated purpose, was solely a patriotic purpose, correct?
Of this statute, Your Honor.
Right, and this school district and the people implementing it. They were solely trying to say, let's have a few minutes of patriotism every day, correct?
That is correct, Your Honor. However,
And then they said, which wouldn't be unreasonable, well, let's look around at what kind of documents we have. We can do the pledge, that'd be one. They could do the Gettysburg Address, they could do the Declaration of Independence, they could maybe read the Constitution. Any of those would be patriotic documents or statements, correct?
that is correct, Your Honor.
So do we have anything in the record that would suggest that the purpose here in giving the Pledge of Allegiance as an acceptable example is anything other than patriotic and secular?
Well, yes, Your Honor, if I may point back again to McCreary, which said that the entire legislative history should be at issue. I think the real test in terms of the endorsement standard is what
Well,
the
that doesn't
reasonable
really
effect-
answer, that's a different question. You're now telling me that McCreary wants us to look backwards, even though there were not federal and, local government involved there. My question is whether there's anything in the record to suggest as to this district and this policy that we have in front of us, that it is anything other than a policy to promote patriotism?
Well, I would point to two things, Your Honor. First, I would say that purpose is not always dispositive, and that when there is a possibly religious effect, that can make an exercise impermissibly religious, even if the purpose is not necessarily so. But moreover, I would say that in today's world, especially given the easy nature of information exchange, it is entirely possible for any reasonable observer to know the history of the Pledge of Allegiance, including the 1954 amendment, and therefore to understand that even when a school district chooses to adopt the entire Pledge of Allegiance as it has been codified, there is an understanding that there is a religious background.
Is effect enough for you here? Is it enough to show effect?
Your Honor, I believe that there is enough.
If it is, why are you charging up this hill of legislative intent and trying to reach back to 1954 in the first place?
Well, Your Honor, I do not believe that we need to show purpose as an independent dispositive fact. I believe that purpose is a fact.
Especially where it's so attenuated from a presidential signing statement to a policy adopted by a school district.
That is correct, Your Honor. I believe that the effect here is the stronger argument. And in this situation, as I began, the most likely effect for a reasonable observer would be to understand the words under God to connote a religious endorsement of a specific belief.
How do we know that Congress endorsed monotheism because of the phrase under God? Because it's capitalized? What if it was small letter G and put an S on it? Under God, would that be sufficient?
Well, Your Honor, in that case, I would say that you would have an impermissible endorsement of a different kind of specific religion. The court has held...
It would not be monotheism.
That would be polytheism, which would be equally impermissible. The court has held that even any specific religious understanding by the government to the point of excluding atheism is in fact impermissible. Moreover, this court held in McCreary that, for example, the Ten Commandments indicated when they said God that they were referring to the Judeo-Christian God. And in this case, I believe that the reasonable observer would draw a similar inference.
But you know, the difference, of course, is that the Ten Commandments don't actually have an historical place in the founding of our country. And it seems to me that there's got to be some baseline common sense to this for what has been referred to as civil polity. Isn't that really what the Pledge of Allegiance is? Isn't it basically a patriotic pledge that distinguishes it from prayer and from the Ten Commandments?
Your Honor, the Pledge of Allegiance overall does have a patriotic tone to it. However, what happens in this context is that the other highly regarded values, such as liberty and justice for all, actually lend that value to the phrase under God, and in this case, make it one of the founding values that is identified with the United States. That is one of the strongest reasons why it is so impermissible in this case. Where a student says, I pledge allegiance, and then that follows with a list of values that this country is identified with, liberty and justice, and a one nation under God, that in fact creates a more impermissible endorsement than if it were merely the phrase standing alone.
When the students go on a field trip to the Supreme Court and hear God save the United States in this honorable court, is that an impermissible activity?
Your Honor, I would distinguish that for several different reasons. As my co-counsel discussed, that does not require the same kind of direct affirmation that is present with the Pledge of Allegiance. But moreover, this court has recognized on numerous...
Same kind of endorsement, though, isn't it?
It would be an endorsement. However, in that situation, this court has found that because there is not the overarching school context, there is not the same kind of endorsing value to it. Whereas here, the Pledge of Allegiance is being led by the teacher, the single most authoritative figure in many of these students' lives during the school day. There it has an increased endorsing effect because the students are more likely to see that the person who represents their authority and in fact the state's authority is requiring them.
Are the teachers allowed to teach about the religious foundations of the country?
Yes, they are, Your Honor. In that situation, you have several other factors.
Couldn't that be just as coercive, just as much of an endorsement if you taught the history that way, indirectly?
Well, Your Honor, in that situation...
Read the Supreme Court opinions and said we are a religious people?
Your Honor, in that situation, you would have a couple distinguishing factors. First is that there would be a much more encompassing historical discussion regarding the founding religious beliefs of this country. Here it is simply rote recitation of an affirmative religious belief. So you do not have the same kind of...
You think it's better to have the full-out explanation that kind of gives the whole history and why this is been the case throughout our history as opposed to the rote recitation.
Your Honor,
One could argue it's more dangerous.
That is possible, Your Honor. I would contend that in this situation there is a difference between internalizing a history and affirming a belief, where a student is required to learn, say, the Declaration of Independence or the Gettysburg Address. They are learning the history of religious belief in this country or in any country. And in that situation, the student is less likely to believe that the state today endorses those beliefs. Whereas with the Pledge of Allegiance, when a teacher says in the present tense, I pledge allegiance to the flag, the historical context in that situation is not present. And so in that situation, the reasonable student or the reasonable observer is more likely to take that phrase as a current endorsement by the state.
Okay, well, let me give you, it's Girl Scout Cookie Week last week and this week, okay? And so let's say the Girl Scouts, per usual, are selling their cookies on the campus of the elementary school, and they also want to do a flag ceremony, which is fairly common for Girl Scouts. So we're not going to have the students join in the pledge, but we are going to have the Girl Scouts march down the aisle with the flag, and then all the little Girl Scouts in uniform are going to put their hand over their heart, and they're going to say the pledge as we know it today. Would that be constitutional? Is that not exactly what would happen here?
I'm sorry, I'm just trying to clarify here. So the students in the school are not...
No, they don't have to say the pledge. All they're saying is it's a ceremony only for the Girl Scouts. There's just like a performance, but they're giving you the pledge, and it's the same pledge, and you have to hear it only because it's a school assembly.
Your Honor, I do not believe that would have the same idea of endorsement. In that situation, you would have the idea of an outside group that is in itself not religious, that is being brought in. Now, were everyone required...
Why wouldn't the child be in exactly the same situation that you argued earlier, which is, I'm in the school, I've got Miss So-and-so, the principal up there, the dreaded evil principal, and she's, bringing on this little program, and I have to listen to this. There's no way I can't listen to it. Why isn't that child exactly the same as your client?
Well, Your Honor, in that situation, what the school principal is doing is saying that these people are coming in and espousing their beliefs, which is different from, say, the teacher in the classroom saying, I pledge allegiance, and leading the students in that same recitation. Where the Girl Scouts come in and say the Pledge of Allegiance on their own, it is less of an endorsement by the state. It is, for example, any time that the state brings in a musical group for a talent show.
What if the principal then said, and join if you wish?
If some students chose to join in, that would be permissible, because in that case there is no coercive effect and no endorsement by the state. The state is merely saying that here are the beliefs of other people which you may or may not agree with, as opposed to the Pledge of Allegiance, where the state is saying here are our beliefs, which the reasonable interpretation is you should agree.
So the only difference would be then, in my example, the principal says join in if you want, and in the classroom the teacher says join in if you want. That's the only difference.
No, I believe there is another difference, respectfully, Your Honor, because in the Girl Scout example, it is not a authoritative figure of the school who is creating the religious activity, with the possibly religious activity in the Pledge of Allegiance, where it is merely other people who come in and are not themselves religious and then choose to espouse their own beliefs. You do not have the same kind of governmental endorsement that the Establishment Clause is meant to protect against.
The Education Code requires that public schools begin each day with, quote, appropriate patriotic exercises, plural. What if the school district's policy had been each elementary school class shall recite the Pledge of Allegiance to the flag once each day, first the 1942 codification, followed by the 1954 codification?
Your Honor, in that situation, I believe you would have a similar problem, of course, only with respect to the 1954 version. In fact, you might even have a worse problem, because in that situation, you would actually have the students understanding that Congress at one point chose to add only the words under God, which would create an additional endorsement. Now, the Pledge of Allegiance without under God would certainly be permissible, as this court held in Barnett. And in fact, in that situation, you have a situation that follows closely what this court stated in County of Allegheny and Lynch.
How about a new version of the pledge that I just invented, which it's everything that you're used to, except instead of saying one nation under God, it says one nation founded with a belief in divine providence. Is that okay?
Your Honor, that would be more permissible. I do not believe that it would in the end be allowable, because in that situation you still have the idea that this country is endorsing a specific belief.
Yeah, but I'm not, you're not asking the students in that context to pledge anything themselves other than a belief in a nation that was founded with a belief in divine providence, which seems to be a historically accurate fact.
Oh, I'm sorry, I misunderstood the original. It is merely a founded, it is not a belief in divine providence?
Well, it's the rest of the pledge, and then at the point that you get to one nation, instead of saying one nation under God, you say one nation founded with a belief in divine providence.
Assuming that there was enough contextual information for students to know that it was merely a historical statement, in that situation it would be permissible. However, the question would again come down to a reasonable observer and whether or not such a student would understand that historical context.
Who's the reasonable observer?
Well, Your Honor, this court has held, excuse me, in cases that the reasonable
observer know the whole history of the country and the acknowledgement of religion that's occurred throughout the country's history?
Not necessarily, Your Honor. The reasonable observer is the student in this situation, and most likely the dissenter who has, the kind of excuse me, my time is up.
A reasonable student, not a reasonable outsider.
That's correct, Your Honor. However, in that situation, the phrase under God as exists today is most likely religious.
Thank you very much. Case is submitted.
All right. Please be seated. Thank you all for coming here tonight. I'm Jeff Campione. I'm the director of the Appellate Advocacy Division, and I am really excited to have just witnessed that fantastic competition. Congratulations, Laura, Jeffrey, Ari, and Ryan for just a terrific, terrific job. Appreciate you. Relax, enjoy yourselves. It'll be a few minutes for a little bit. While we have a moment, I'd like to thank a few other people and give congratulations to at least one other competitor. As Shauna mentioned earlier, there were 144 briefs that were submitted. People spent their spring breaks writing and working furiously on those. Of those briefs, one stood out above the others. That was particularly excellent. And I'd like to recognize for this competition, best brief was given by Andrew Osha. Andrew, are you here tonight? Whether he is or not, you guys should all know that he wrote a terrific brief and deserves credit for doing so. I'd like to thank several people for making this possible tonight. First, I'd like to say how grateful we are that Dean Alanikoff had played such a prominent role in helping us bring about this competition, was with us tonight. Dean Alanikoff is a big reason why we had such a fantastic panel. He put a lot of effort and advocacy for the Barristers Council to make sure that we had such distinguished judges, and we are really honored by his presence tonight, and we really appreciate the effort that he made. You'll see on your programs listing that Dean Bellamy is our faculty advisor. I think that title doesn't come close to telling you what Dean Bellamy does for the Barristers Council. He is our counselor and our conscience. He is our mediator of disputes and all the drama that students can come up with. And we are just, our ability to organize and put this together as a student organization is entirely dependent on the fact that Dean Bellamy is there to support us at every step of the way. Dean Bellamy, thank you for an entire year. There are 84 people this year on the Appellate Advocacy Division, most of whom can pronounce it besides me, many of whom participated in making this tournament possible. I'm grateful to all of them, but there are several that I want to thank in particular. If you were in Hotong any of the last few nights, you saw Nick Austin and Kim Witherspoon furiously putting together all of the information about the scores of this tournament, trying to make sure everybody got to the right place, was in the right room. I'm grateful to Nick and Kim for their efforts. Jinwoo Park led a group
that put this packet together, and many of you remember from first-year con law, a case that sounded somewhat similar to these facts, but had a whole lot of other issues involved, like standing. Junwoo led the effort to make sure that this was a case that we could argue strictly on the merits and on the substance of the law, and made this a great event, and I appreciate the effort they made. We had the advantage of having two great veterans. Last year, Alan Tannenwald and Ben Schumann were directed and co-directed this competition. This year, they made sure we had judges in the right place at the right time. They made sure all our scores were correct. They advised and told everybody, make sure that we did all the things that are necessary to run the competition, and I'm grateful to Alan and Ben for that. But most importantly, somebody has to run this thing, and it is about the hardest job you could possibly imagine, coordinating a bunch of law students who have a million other things to do, who don't want to be here, and to try to get them all to coordinate and put together this tremendous effort. It began in August, and the person who volunteered for that effort and who has led it beautifully throughout the entire year, I'm incredibly personally grateful, Shauna Pruitt, for running this competition. There will be all of the quarterfinalists who in this competition will be offered positions in next year's moot court team. There are also a number of people who competed in competitions for the ADR team and the mock trial team who will soon be extended offers. We are really excited to have so many qualified and extraordinary people who lead the Barristers Council for the next couple of years. I'd like to thank you all for being here tonight. Enjoy the few moments of rest while we wait for the judges. Thank you.
Seated. Thank you. The court has reached a verdict, and I must admit that each one of the judges was very impressed with the arguments, your demeanor, your ability to answer the questions. In some cases, the hypothetical questions might have led you astray, but you went right back on track, and all of you did very, very well. Being 1Ls, it's an indication, in my judgment, of the good training that you've been receiving in law school, and the ability to present an oral argument is not easy. I think overall, this augurs well for your future careers in the law. And you will also note that the arguments were not comprehensive in the sense that you were limited in the records that you could use in putting your briefs together and also in presenting your oral argument. However, as one of the panelists, I think you did a marvelous job, and you will do very well. Your poise and your demeanor were commendable and excellent. Each one of the judges will now give you their own personal reviews, and at the end, we'll announce the winner. Judge Kavanaugh?
The suspense. Well, I just want to say, I think the performance was outstanding, all four. And it's a real tribute to the school and to your professors, a tribute to each of you individually, to your family and friends who probably endured a little of the stress that I know goes into preparing for a competition like this. So each of you is to be commended and congratulated on an outstanding performance with a tough set of issues before a panel that grilled you pretty well. So you all did a tremendous job, answered the question. I thought you all really were excellent at turning a difficult question and returning to your themes and never forgetting your affirmative points. You really stayed, you weren't shaken too easily, I'd say, and that went for all four of you, and that was really a skill, because it's hard in an oral argument not to get pushed around and start sliding down the hill, and you all maintained your ground well. So congratulations, a real tribute, as I said, to at the beginning, to all four of you.
Justice Clement?
Well, I've had kind of a long day, so I'll keep this short. I really thought you did a terrific job, and I echo certainly everything Brett said, and I would just emphasize 2 points why, I would describe what you did as really terrific, and this applies, again, to all four of you. It was really very well done. And the 2 things I thought that you did really well is, first, you answered the questions, and that may seem like, sort of an obvious point, but you actually did. I mean, you avoided the presidential debate format where you didn't hear a question that evoked a topic area and then gave your best soundbite related to that topic area. You actually tried to answer your question. You tried to answer the questions and answer them quite directly, and you didn't walk around the hypos. You answered the hypos, and then the second part of why I thought you did a terrific job, which actually needs to go together or it can lead to ruin, is that you knew kind of what you could concede and what you didn't. And I think both sides had a pretty good sense of what their theory of the case was. And so in confronting the various hypotheticals, there was a great sense of, look, this is the core of my case, this is the periphery, that's something that I can give away because I can retreat to this core. Wait, that's ugly, that hurts, I don't really like that question, but that's in the core, so I better say that that's, that that's not okay or that's okay, depending on the side. And I thought your ability to combine those 2 traits, to answer the questions, not duck them, not just foul them off, but actually try to hit the pitch as thrown, along with the ability to do that without sacrificing your case, I thought was just terrific. So my hat's off to all of you.
Justice McKeown?
Again, like the other panelists and justices here, I thought this was really a terrific argument. I was mentioning to them, I've heard this argument before at a different school, not in court. And I just can't tell you how superb this argument was. Let me just make a couple comments on why I thought so. Well, first of all, I think this is a very difficult moot court problem because it does not divide in 2 very easily. And so most moot court problems, there's A and B, and you can stick to that. What I thought was really quite impressive is I know each of you were prepared to do A and then B, but you had the facility, because everything is so interrelated, that you really knew your case. And that happens a lot in court. You come in and you want to talk about A, but the judges want to talk about B and C. And you have to have that flexibility and that kind of nimble nature. And I thought that was incredibly evident here, particularly because it was an exercise designed to be divided in 2, and you didn't have to respond that way. So I thought that was incredibly superlative. Second is, oftentimes people view the questions as if, we're launching into a fight with them, and they look like deer in the headlights, like, oh my God, a question, and it's, incoming traffic kind of thing. And, you were all incredibly calm. That you took the questions, I thought, and turned them into answers that made a couple of your high points, and you were really good at that. The third thing I thought was very impressive is that, it's very easy in a moot court in a very short period of time to be thrown a question, to be thrown a hypothetical, and you give a really pretty pedestrian answer. It's an answer, but it's pedestrian. And I thought that we saw here some real facility among among those arguing to actually give some nuance to the answers. And I thought that given the nature of the problem and also, the difficulty of the case and the issue, that you did a really great job in that. So I would just say, anytime you want, come out to the 13th or the 9th Circuit. We'd like to see you.
Justice Smith?
I would be redundant if I said much, but I'll do it anyway. Not much, but redundancy. Again, kudos. All 4 of you were excellent. I have only served on the Court of Appeals for less than 6 years, but this is my 20th year as an Article III judge, and I've done a lot of these over that period of time, and you were all superb. truly one of the best, if not the best, I've witnessed and participated in. Again, along the line of redundancy, echo Paul's comment. What strikes me is that you did all answer the questions, and you did it with directness and seeming ease and alacrity. Not once did we hear in response to our hypotheticals, some of which intended to try to throw you off. That's not our case, or that's not this case. A very annoying response when one hears it, but we did not hear it here. Finally, a thank you and a congratulations to all of the organizers who have treated us as a panel very well, and whom I know have been very helpful to all of you. So I want to express my personal thanks. I'm sure the rest of the panel does as well. We were prepped very well by them with the materials in advance. In fact, I was rather relieved. In reading the instructions for the competition, I came upon one that says, competitors may not request a recusal from the bench, and this was a relief having come a considerable distance here. So I thank all of you. I congratulate all of you.
Well, we've come to the end of the round of Beaudry competition. I must admit, when I was here at Georgetown, it was one of the more competitive programs that we had. I participated but not get to the finals. I think it's a great opportunity for you to appear before a panel of judges. And selecting a winner is always very difficult because you've risen to the top, and the four finalists are usually the best of the best. And trying to say whether one person is better than the other, I think is very difficult, even for judges. You were all well done and well presented. So we've come to the final conclusion, and this is unanimous opinion by the judges, that Ari Meltzer was the best of the presenters. Ari, congratulations.
Before I say all rise one more time, another hand for our spectacular panel. All right.
Get yourself some rest. Thank you.
All right, everyone, thank you so much for attending, and we have a reception right out here in the lobby, so please join us. Congratulations.
You're going to be here in the salon. Congratulations.
Congratulations. We hope you'll make the right choice.
Congratulations.
Thank you.